Rollins case, the most important prohibited transaction case you need to know. Hey everyone, Adam Bergman here, tax attorney and founder of IRA Financial. And today's AdBits going to be discussing and dissecting the 2004 Rollins v. Commissioner case. I've talked about this case a lot. I've written many blogs on it. It's definitely referenced in most of the 9 books I wrote on self-directed retirement accounts, but I really want to do a podcast to really review it. It's been 10 years or so since the ruling came down, but I think it's one of the most important prohibited transaction cases because it gives you really clear picture into the IRS's thinking on how they want to attack an IRS prohibited transaction. So I'm going to just briefly describe the facts of the case, and then we'll talk about the prohibited transaction, section 4975. And then I'm going to explain why I think this case is so important. So this is as I mentioned, 2004 tax court case. The citation is Tax Court Memo 2004-260, Joseph Rollins v. Commissioner. As I mentioned, November 15, 2004 was the date the tax court ruled, and it ruled in favor of the IRS. But the facts are very interesting. So this guy, Mr. Rollins, is a CPA and an RIA, registered investment advisor. Rollins owned 100% of an accounting firm, and he had a 401k plan as part of the accounting firm. Rollins owned 100% of a financial consulting, a counseling firm too, and an RIA. And Rollins made a decision to lend the 401k's money to a number of companies he was associated with. And I'm not going to mention all of them, but he owned, in all cases, all less than 50%. So one of them was the J&J Charlotte. He owned less than 10%. One was the Eagle Buff. He owned 27%. But the company had 80 other partners. One, he owned 33%, but there were 70 other partners. And he lent the money at prevailing interest rates. The companies actually paid the 401k back. There was no default, and everything seemed to work according to plan. Somehow, the IRS audited Mr. Rollins. Not sure how they uncovered this, but they argued that Rollins did a prohibited transaction. And essentially, there's 3 things you cannot do with an IRA. Section 408M says you can't buy life insurance, can't buy collectibles like art. This case focuses on section 4975. And 4975C, basically A, B, C, D, and F, talks about certain things you cannot do with your IRA or 401k. And I'll just briefly go through 4975 and just kind of summarize the A, B, C, 1A, B, C, D, E, and F. So C is all the things you can't do. So the basic stuff, the crux behind the rules, and the intent is, hey, if you're going to do something to personally benefit yourself or a disqualified person, and a disqualified person is defined as you, your lineal descendants, your parents, your children, your spouse, daughter-in-law, son-in-law, or any entities controlled 50% or more by such persons, you shouldn't do it because that's probably a conflict of self-dealing. And if we let you do it, then no one's going to ever take a taxable distribution, right? So we got to make sure that if you really want to use it for personal purposes for you or your family, just take a taxable distribution and then do whatever you need with it. But you need to respect the distribution rules. So 4975C1A says you can't sell or lease or exchange property between a plan and a disqualified person, right? Sell real estate between your IRA and your kid. You can't lend money between IRA and your spouse. You can't provide services between IRA and an entity you control 50% or more. You can't, and then D, E, and F, or the following D and F are all the catch-alls, like more broad. Transfer to or use for the benefit of a disqualified person, the income or assets of the plan, right? Act by a disqualified person who's a fiduciary, where I'm dealing with the assets or income of the plan for my own personal benefit, right? And receipt of consideration for my own account, who's a disqualified person, from plan assets. Okay, so the idea again is you want to separate yourself from the retirement investment. And if you make an investment with your IRA, it must be exclusively to benefit your IRA, not to have any direct or indirect personal benefit to yourself or a disqualified person. So remember, the control is 50%, right? If an entity is disqualified, generally it's a 50% threshold. So in the Rollins case, all these entities I previously mentioned, he all owned under 50%. Okay, so on its face, Rollins should have been able to lend money from the 401k to these companies. The problem is some of the facts. So the facts are that the companies needed money. You can say, well, anyone who borrows money needs money. Well, the IRS essentially said, the only reason your 401k lent the money to these companies was not because it's a good investment for the 401k. It's because you personally wanted to happen to help you personally, because you were the largest shareholder in a lot of these deals. And if the businesses didn't get the money, they go belly up and you lose your personal investment. Now, Rollins argued, no, he goes, no, we're under 50%. It was a good loan. It was a good investment for my 401k. The money went back to my 401k. Everything got paid off. What are you talking about? And basically the tax court said, hey, Rollins, the burden of proof's on you as the taxpayer, and you did not satisfy that burden, and you were not able to prove to us that the loan from the 401k to these businesses were not done to personally benefit yourself. And Rollins kept going back to the fact and said, hey, I'm under 50%. I can make this loan. And the tax court said, that's fine, but you didn't prove that you didn't benefit. And his argument is, I didn't benefit. The companies paid the loans back. It was a good investment for my 401k, and it should be respected. And unfortunately, the tax court sided with the IRS. And it's a very interesting case because it's one of the few cases where you have a prohibited transaction that actually is a facts and circumstances gray area. Because most of the cases that go to tax court, the IRS doesn't like to litigate gray area fact intensive cases. They usually want slam dunk cases like you own more than 50% of an entity and your IRA invests in it. It's prohibited. Or you lent money to a company controlled by you. It's prohibited. It's obvious. You're stupid. This case is unique and very, I think, distinct because Rollins owned 50% or less in all the companies that the 401k lent money to. And still, the tax court agreed with the IRS that he personally benefited, that he couldn't prove that the transactions were done to exclusively benefit his plan. So the worst fact he had was the companies needed the money. If he was able to show that he had 5 banks lined up to do this loan, he probably wins. I think he's got a very good chance to show, hey, I only did the loan because it was a great investment for my 401k. I had 4 other banks lined up to do this loan at the same interest rate, but I wanted my 401k to get the rate of return. But he couldn't prove it. And again, the tax court said, you're the taxpayer, the burden of proof is on you. I think it's a tough judgment. I mean, I understand if you're Rollins and you look at the tax code, and you said, hey, I own less than 50%. I'm passive. It's not my active business, right? I'm an accountant. I'm a registered investment advisor. It's not even my full-time gig. I'm just a passive investor. How can you argue that this is prohibited? That's crazy. That's super broad and goes beyond the core of the rules under 4975 C1 D E and F. But the evidentiary record did not support his position that the security of the finance was independent of a lender. Like, he needed to show that the loan was independent of his personal involvement. So maybe if he had another person approve the loan, if he wasn't involved with it, if they could have shown that there were other lenders, I think he probably prevails, but he didn't have the right facts. So this is a good example of the importance of working with a self-directed IRA company, like IRA Financial, that understands these rules, that has done hundreds of thousands of investments, has 25,000 plus clients, that has seen it all, right? And with our expertise, I've written 9 books on the subject. I've seen it all. I've studied every tax court case, all the revenue rulings. I know where the pitfalls are, and my team does as well. So this is the kind of situation, if Rollins was our client, we'd say, hey, either don't do it, your facts aren't good, or hey, this is what I suggest you do, right? Have a third party approve the loan. Go out and find the financing from other sources. And if you still want to do it with your 401k, you have credible proof to show there is separation between you as a lender and then your 401k as a lender, and then your personal capacity as an investor in these deals. but he kind of was on both sides of the transaction. They didn't like that. I think if he was properly advised, he could have maneuvered his way around there with some better structuring to prevail, but it didn't work out with him. So almost 10 years since this ruling came out. Well, 10 years. What am I saying? 20 years since this ruling came out. 2004. God, I can't even count. That's why I went to law school and not an MBA. I said 10 years in the beginning of this podcast. It's 20 years. You're probably listening and say 10 years. What is this guy talking about? Yeah, 2004. It's hard to believe it's 20 years. God. So I wanted to kind of review this case because I think it really, if you're studying the prohibited transaction rules, this is the most important case to study because you get to see the most aggressive position taken by the IRS. And then you also, at the same time, can kind of see where Rollins went wrong and how you could potentially protect yourself in a much better fashion by understanding the Rollins case versus not knowing the facts and the ruling, because the IRS was super clear that, hey, the burden's on the taxpayer, facts weren't good. You need to show a total division and separation between the retirement account as a lender on one side and then you personally on the other side. So having a third party approve it, you not being anywhere involved in the loan negotiation, and then obviously having other sources of financing available to at least show that you had options, the company had options. And the reason the 401k entered in this transaction was not to help you personally, because you also had other loan options, was because it was a good rate of return and a good loan investment that was safe and secure. So one of my favorite cases to teach on, because it really is interesting to kind of dissect the opinion. I think they got it wrong personally. But you don't see a lot of these cases where the facts and circumstances play such a heavy role. So thank you for listening. Sorry about the 10 versus 20 years. That's just me doing bad math, but hope you kind of understood. It's a really interesting ruling to review. I'll make sure the citations in the podcast notes, you can click on it and check it out. But I think this podcast gave you a pretty solid summary of exactly what happened, some of the pitfalls that Rollins experienced, and why ultimately the IRS ruled for the IRS instead of Rollins, which was quite I think shocking at the time. So that's it for today's podcast. Hope this was insightful and interesting, and hope to see everyone again next week. Ciao and have a great day.